We're going to resume with our second panel. Is ecocide a viable international crime? I'm very pleased to introduce the chair, Paul Williams, the Rebecca Grazier Professor of Law and International Relations at American University, and the president of the Public International Law and Policy Group.
Great. Thanks, Avni. After 30 years of being in academia and arranging panels, I have finally figured out how to arrange the most amazing panel. It entails sitting at home with my COVID puppy, playing fetch, and waiting for the phone to ring. And Milena Stereo calls you up and says, "So Paul, I have arranged this most amazing panel on ecocide with phenomenal experts from around the globe." And of course I said, "Well, you know, Milena, I'm happy to make time and to join the panel and do a presentation." She says, No, from amazing experts around the globe. I need you to introduce us. And so that is my role today. And in fact, her panelists were so amazing and so wonderful that Michael Scharf stole one of our panelists and made Chile the keynote speaker for lunchtime. So we are associating all of Chile's lunchtime remarks with our amazing, amazing panel. We are going to talk about whether ecocide is a viable international crime. So I thought I would, create some momentum, get you in the mood, provide you an intellectual framework for the conversation by our panelists. So, let's start first of all with the definition of ecocide. Ecocide is the intent to destroy in whole or part a forest through, no, that's not the definition, Milena? Well, there really is no agreed upon definition of ecocide, so we'll put that aside. But it's okay because ecocide has been established in a number of international instruments. A treaty, no, John says there's no treaty. Customary international law, if there was, the Americans wouldn't want it. A General Assembly resolution. Did we get a General Assembly? No. All right, so there is no international instrument that deals with ecocide, but at least we have a consensus on the elements of the crime of ecocide. Well, Giovanni says no, we don't. There's no consensus there. So apparently we're going to have an open field for our panel discussion in terms of, is ecocide real? Does it have a space in international law? Does it have a space in international criminal law? How do we define it? How do we prosecute it? How do we make momentum moving forward on ecocide? And in particular, what lessons we can learn from John Knox's work for nearly a decade to build a human right to the environment? How do we crystallize and build a right or a cost of action for ecocide? Now, this amazing panel that we're excited to hear about, our first speaker is going to be Milena Stereo, who is a distinguished professor, but I think at the moment the only distinguished professor at the Cleveland State University, where she holds an endowed chair. She's also the managing director of the Public International Law and Policy Group. And if Victoria was here, she would have a comment about what to say, which Milena crisscrosses the globe to protect and promote human rights. Yesterday, she was on Capitol Hill with our PLPG pro bono clients, the Syrian opposition, seeking to find ways to hold Assad accountable for his war crimes, including many of his environmental crimes. Tomorrow, she's heading to Poland for the Warsaw Security Forum for work on Ukraine accountability initiatives. And then from Poland, she's heading to the Rohingya refugee camps in Cox's Bazar, Bangladesh, where she co-leads our program to document atrocity crimes committed against the Rohingya, which also include a number of environmental crimes. So very excited to turn the microphone over to Milena in just a few minutes. I'm also very delighted to welcome Layla Sadat, who is the James Carr Professor of International Criminal Law. I think we're all envious to have a chaired professorship of international criminal law, where you just spend all day thinking about how to make the world a more secure and a better place. She's also the chair of the board of directors of the American branch of the International Law Association, and served for over a decade as the special advisor on crimes against humanity to the International Criminal Court prosecutor. And this is my introduction, it's like 6 pages long. And she's also the primary architect of the Crimes Against Humanity Initiative, which is a groundbreaking project that she launched that wrote the world's first treaty on crimes against humanity and continues to work for its adoption by the United Nations. And we saw a little bit of that conversation with Layla and John this morning in the Q&A, treaty versus General Assembly resolution. And I'm honored to welcome Giovanni Chiarian, a lecturer in international law and international criminal law at the University of Huddersfield in England. He's also an attorney admitted to the International Criminal Court list of the Assistants to Counsel. And notably, Giovanni recently served as a visiting researcher on ecocide at the University College Cork in Ireland. So he will have some answers to those questions as well. So with that, we're going to turn it over to the three panelists. They will do 12 minutes each. We will then leave plenty of time for Q&A. We are going to do our first solicited question to Amanda Price, who wrote her law review article for Case Western Reserve International Law Journal on ecocide. So just a heads up, 36 minutes from now, we're going to turn to you for the first brilliant question or comment. Milena, the floor is yours.
Thanks, Paul, for the very kind introduction. I am a little bit embarrassed, though, because, you know, carbon emissions, I'm flying around the globe. So I'm not sure you should have said that, but nonetheless, thanks for the kind words. And thank you to Dean Michael Scharf for organizing this conference and for putting all of this together. It's a pleasure to be here once again. So we have seen an increasing awareness about the environment. And as our previous panel has emphasized, in particular Professor Craig Martin, we have seen litigation at both the national level as well as at the regional and international levels, basically human rights litigation, civil litigation, attempting to hold governments responsible for what they do, or for more importantly, for what they do not do in terms of their duties to protect the environment. Our panel will build on that discussion by talking about how one can impose individual criminal responsibility on those responsible for the commission of ecocide and other environmental crimes. And although civil litigation, human rights litigation is obviously different from this field of international criminal law and the imposition of individual criminal responsibility on corporations or on world leaders, what the two have in common is the realization that harming the environment is a particularly serious offense, and that more needs to be done to stop states, government leaders, and corporations from continuing to harm the environment. I will, in this brief talk, address 4 different points. First, I will talk a little bit about the history of the crime of ecocide. Second, I will talk about the Rome Statute and how crimes against the environment are contemplated within the Rome Statute. Third, I will mention the Stop Ecocide campaign and talk a little bit about their proposal to develop ecocide as a 5th crime within the Rome Statute. And fourth, I will say just a few words about prosecuting ecocide as well as other environmental crimes at the national level at different national courts in countries which have criminalized such acts. I was about to say all of this in 12 minutes, but I see that the timekeeper has said I only have 10 minutes left. So first, the history of ecocide. So the term ecocide is not exactly new. It was first used as early as around 1970 at a conference where Professor Arthur Glaston proposed the development of a new international agreement to prohibit ecocide. And although there was no definition of ecocide at that time, as there might not be now, as Paul just told us, the crime was understood back then as essentially destructive measures aimed at damaging or destroying the entire ecosystem of a specified geographic area, causing the loss of human, animal, and plant lives. Richard Falk, one of the most prominent US-based scholars, around the same time proposed an ecocide treaty, which would have recognized that people, men and women, have consciously and unconsciously inflicted irreparable damage to the environment. And he thus drafted the International Convention on the Crime of Ecocide. And I would mention just that convention contemplated ecocide mostly as a war crime. Over the subsequent decades, there are records that exist showing that ecocide was being discussed as a crime against peace, which would have been included in an amended version of the Genocide Convention. And then most notably, the 1993 draft Code of Crimes Against the Peace and Security of Mankind, developed by the International Law Commission, included ecocide as a crime against peace. And obviously, I'm skipping around a lot. I'm just giving you a very brief nutshell, preview of the history of ecocide here. What's interesting to note, though, is that, as we all know, ecocide did not make it into the Rome Statute of the International Criminal Court. What's also notable is that only 3 countries were on record officially as opposing the crime of ecocide within the Rome Statute. These countries including the United States, the United Kingdom, and the Netherlands. And actually, Leila, if you have time within your 12 minutes, I'd love to hear more about, the history of the Rome Statute and what exactly was discussed at Rome about crimes against the environment. So we don't exactly know why the crime of ecocide was excluded from the Rome Statute, but one of the key rapporteurs has stated as follows, quote, "One cannot escape the impression that nuclear arms played a decisive role in the minds of many of those who opted for the final text, which has now been emasculated to such an extent that its conditions of applicability will almost never be met, even after humankind would have gone through disasters of the most atrocious kind." That then leads me to my second point, which is, well, okay, so what exactly is in the Rome Statute of the ICC? The ICC's Rome Statute contemplates crimes against the environment as a war crime. Article 8.2b of the Rome Statute provides, as one of the enumerated war crimes, the intentional launching of an attack in the knowledge that such an attack will cause, quote, "widespread, long-term, and severe damage to the natural environment, which would be clearly excessive in relation to the concrete and direct overall military advantage anticipated." Although this war crimes provision has never really been used in any ICC cases, the Office of the Prosecutor has indicated in its 2016 policy paper that would prioritize crimes that result in the destruction of the environment, exploitation of natural resources, and the illegal disposition of land. And in the same policy paper, the OTP also indicated that it would provide cooperation and assistance to ICC member states regarding their own investigations and prosecutions of crimes related to the destruction of the environment. As of now, the ICC has not investigated and prosecuted cases involving charges of the war crime, crimes against the environment, despite the OTP's resolve to focus on environmental issues. And so in light of this, the Stop Ecocide campaign has recently been campaigning, proposing that ecocide be developed as a 5th and separate crime within the ICC's Rome Statute. So this will be my third point, the Stop Ecocide campaign. The campaign recently convened a group of experts, the so-called Independent Expert Panel for the Legal Definition of Ecocide, which developed, proposed a definition of ecocide as, quote, "unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts." Now, I know that Giovanni, in his slides, has more to say about this, so I will be very brief. This is obviously an interesting and important campaign. It is, difficult to say that it will be successful. I think some of us, wish it success, but I don't know that there's necessarily the political will to actually go ahead and amend the Rome Statute. I would also add that in addition to the campaign itself, 2 island nations, Vanuatu and the Maldives, have also lobbied the ICC to consider amending its statute to include the crime of ecocide. Belgium has also asked ICC member states to consider the possibility of adding ecocide as a 5th crime to the Rome Statute. And then French lawyers filed a request with the ICC on behalf of Amazonian indigenous groups, asking the court to investigate Brazil's former President Bolsonaro for crimes against humanity. So in that filing, although they weren't talking about ecocide, the same group of lawyers has specifically stated that they would be in favor of also developing the crime of ecocide as a 5th crime. Now, obviously, even if ecocide were to be developed as a 5th crime within the Rome Statute, we all know that the Rome Statute structure has limitations, inherent limitations within it. So any prosecution would still need to meet the gravity threshold. We we are facing the complementarity regime where the relevant state could say, no, you, the ICC, back off. We're going to go ahead and investigate and prosecute. And then we all know that the ICC has limited time and resources and obviously could prosecute only a handful of crimes. Which then leads me to my last point, which is, well, what about prosecuting ecocide and other crimes against the environment at the national level? The crime of ecocide is criminalized at the domestic level in several different countries, and just to name a few, these include Ukraine, Russia, Vietnam, Georgia, and France, and many others. It's important to mention that these domestic level prosecutions can in some instances be held against corporations, which is another, I would say, limitation when it comes to the Rome Statute of the ICC, which can only exercise jurisdiction over natural persons, not corporations. So at the domestic level, these domestic level prosecutions can complement the work of the ICC, can complement the work of other regional tribunals in order to impose individual criminal responsibility against individuals and corporations who commit criminal acts against the environment. And to then come full circle, as I mentioned at the beginning, there's also civil litigation, human rights litigation. I would argue that such national level criminal prosecutions can be complemented by human rights, civil litigation in the same country or in different countries. And to conclude, while we all may disagree about the specific ways and methods that we should use to protect the environment, I believe that it is fair to say that all of us agree that we do need to do a lot more through both criminal and civil law at the international, regional, and national levels to protect the environment. Thank you.
Thank you, Malika. Giovanni, over to you.
All right. Okay. Here we are. Okay. So first, thanks a million and for the invitation from Microsoft, Milena Stereo, all of you. I'm very honored to be here in between two great the best international criminal law scholars. I read a lot from them, so I'm very honored to be here. My presentation will be very basic. I'll be presenting, in fact, my draft paper I submitted called Ecocide in War and Peace. The title is inspired from one of my favorite books, is Lev Tolstoy, War and Peace. And I'll be analyzing two possible prosecutions of ecocide, one in time of war, one in time of peace. So I'll be dividing the presentation essentially in four parts. First, a brief introduction to ecocide, to the history of ecocide. Then the two cases. The ecocide in war, I choose an analysis of the air pollution consequences of the war in Ukraine. Because there is some scientific studies that can prove that after the war, there could be an ecocide. And one, even the Japan's disposal of Fukushima treated radioactive water into the Pacific Ocean. So they're very different cases. And in the conclusion, I will be proposing some additional amendment to the ICC legal framework. So, as already mentioned by Milena Stereo, the history of ecocide is not so recent. It's not in 23 years ago created by the Stop Ecocide Foundation. The term, which is a neologism, ecocide is a neologism, no? Derived by two ancient words. The Greek oikos, which means house, home, and the Latin cedere, which means to destroy, to kill. So to kill our house, our common house. It was created by this botanist, Arthur Galston, related to the Vietnam War, because here you can see in the photo, the US Air Forces sprayed this defoliant, Agent Orange, totally destroying the environment for decades of the both forests of Vietnam and Cambodia, former Indochina. Galston said Agent Orange destroyed one of the most important ecological life cycles ever. And actually, it wasn't just Agent Orange, they called rainbow herbicides because every barrel has a strip, different color with different military purpose. Defoliation, crop destruction. This is actually a picture from the Vietnam Veterans Association, because also the veterans were exposed to the Agent Orange and suffered terrible disability. I met one in person, actually, veteran, who sent me this photo. This is the effect of the Agent Orange. You see, the land on the left hasn't been sprayed, the land on the right has. So it's totally destroyed the environment. And Galston made a great work in sensibilizing the discussion of ecocide, and he proposed a classification of the damage which is triple for Galston. Galston said ecocide causes damage to the environment that we cannot touch, the air, to the environment that we can touch, the cultivation, the agriculture, the soil, and directly, indirectly, to human beings and other form of life, so animal, and I think it's still valid, this classification. There are still protests. This is a photo of 10 years ago in Vietnam, because then the exposure to Agent Orange to women causes birth defect to thousands of child. Anyway, let's go to the current legal framework and just mention the Stop Ecocide Foundation proposal. Because in this paper, I'm not going to criticize the Stop Ecocide Foundation proposal. There will be a lot of criticism, but I decided to apply this definition of ecocide to understand if the ecocide would be introduced tomorrow to the Rome Statute, these two cases would be prosecutable. And so under this definition, ecocide means, as Milena already mentioned, unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. And the Stop Ecocide Foundation then listed this requirement. Severe means damage which involves very residual adverse changes, and they issued a one-page of guideline. And the first case I analyzed, this is a paper, scientific paper from some scientist, it's a Journal of Total Environment, I think, but I mentioned in the paper, that explain all the damage to the environment derived from the Russian aggression. And so I picked the air pollution to analyze the air pollution. And this is actually another paper that explains short-term and long-term impacts of the Russia-Ukraine war, including contaminated sites, permanent changes of profile, ecosystem. The damage to the environment are massive. And it has been said that, of course, every war is in general responsible for high emission of greenhouse gases. And in these particular studies, they showed scientifically, there is a lot of paper actually, I was shocked by the quantity of paper I found, that nitrogen oxide, fine particulate matter, carbon monoxide, ozone level terribly increased. And they explain also why they increase, especially use of cluster bomb, the modern warfare, and also probably the modern instrument of revelation, quantification of the pollution, the technology help in understanding how the war can damage the environment. And so I asked myself, could the air pollution consequences be potentially prosecuted? So let's analyze it with the lens of the Stop Ecocide Foundation. It should be wanton or unlawful. The air pollution is the implicit result of the crime of aggression that lead to the war, so this requirement is satisfied. The damage must be severe. There is scientific studies. I found at least dozen peer-reviewed studies that fine particulate matter, carbon monoxide, ozone level increased. The study actually dated 6-7 months ago, so probably now is worse, the situation. The damage then should be, must be widespread or long-term. On the long-term requirement, actually, the scientific community is divided. I read some, they say there is no long-term damage, but alternative form in the Stop Ecocide Foundation, so it could be also widespread. And there is a study that shows, through the satellite, that the air pollution increased not only Ukraine, but Germany, Poland, Czech Republic, Romania. Thank you. The knowledge, the mental here, everything, could be proved by the decision of Russia to launch the aggression and to continue the conflict. So in my opinion, this could be potentially prosecutable, or at least allows the prosecutor, in case the ecocide will be introduced, to open probably a dedicated investigation on ecocide. This is another scientific schematic of potential mechanism for war impact on atmosphere. This radial cycle is very interesting, scientifically speaking. I don't understand a lot of science, but it's very interesting also the interconnection that ecocide creates with us, jurists. That's why also Arthur Gaston and Richard Falk proposed a conversation between experts in ecology, environmental science, and lawyers. this is another study. They use this Sentinel-5P and optimized machine learning to understand the air quality in Kyiv. And this is still a scientific, there was scientific evidence. I'm skipping because I don't have a lot of time. Yeah. And that's the other ecocide in peace regarding the Japan decision to release treated radioactive water into the ocean. More than 1 million metric tons of contaminated water. Here, the situation is interesting because first, the United Nations experts expressed deep regret. The discharge will impact millions of lives and livelihoods in the Pacific region. And the decision has been criticized by a lot of scientists. Then, recently, the International Atomic Energy Agency, which is the most authoritative in the field, said, no, the Japan plant is safe. So they're not talking about it. But there is a plenty of scientific papers, also peer-reviewed, that prove that the decision of disposal can destroy the environment. So also this, Japan is a state party, could be at least allows, in my opinion, an investigation. This is there's a lot of Chinese legal sources, actually, that expressly accuse Japan of ecocide for dumping nuclear chemicals. And also here, the Japan decision could be considered inferior and unlawful, no? Because the state shall take individual jointly appropriate measure with the Convention of Law of the Sea necessary to prevent, reduce, and control pollution of the marine environment from any source. The damage is severe. In all the studies, so the scientific community is divided, but at least they can allow the prosecutor to open an investigation. If, no, a reasonable standard to proceed. I don't say conviction. We see in a trial. And then, long term, here, I think also the UN independent experts have mentioned that radioactive hazard of tritium have been underestimated and could pose risk to human and environment for over 100 years. 2 minutes, I'm going to conclude. This is all the studies, very interesting studies. 100 scientists in the US, including associate professor, full professor, have published this idea. So there is I think the International Criminal Court here can also promote the dialogue, shed light on this situation. Leukemia risk, thyroid risk, all the studies that can prove. And then I ask myself, I conclude in 1 minute, could the ICC be the viable court for ecocide prosecution? We all know that there are plenty of problems in the ICC. I listed both, tried to propose amendments. First is the lack of environmental law knowledge in the ICC legal officer and judges, and then the lack of jurisdiction of the corporation. So I proposed, because I'm a dreamer, I proposed a lot of amendments. The current list of the judges in the ICC, there are two lists. List A, expert in criminal law procedure with practical experience. List B, expert in public international law, also without practical experience. I'm simplifying. Let's add a list C, with expert in environmental law. Because when I studied these cases, I found a lot of difficulties, actually. Because I don't have enough knowledge in environmental law, animal science, killing of wildlife, climate change law. So I proposed to add a list C on judges expert in environmental law. For the same reason, and I'm going to conclude, I proposed the establishment of the Office of the Special Prosecutor for Ecocide. So a dedicated office, independent, separate from the Office of the Prosecutor, because in my opinion, the Office of the Prosecutor is too discretionary. They now working on guidelines to establish some special chamber specialized in crime against the environment. I would like to establish a dedicated prosecutor only for the office, and then I propose the norm. I conclude, the last amendment will be introducing corporate criminal liability. This is on the basis of the UK legal framework. So essentially, the court shall have jurisdiction of a corporation if a corporation is unable to demonstrate that it had reasonable adequate procedure in place to prevent the facilitation of crime or it failed to prevent the crime of ecocide. So this is in short the structure of the draft paper, and all the feedback, especially critical, are welcome. Thank you, and sorry for taking longer.
Thank you, Giovanni. Leila?
Thank you so much. And thank you to Dean Michael Scharf for the invitation to be here, and to the two centers co-sponsoring this conference. And it's thrilling to hear that you have a new center on environmental law, which is extraordinary. So what I'd like to do is build upon these two really superb presentations to take the conversation in a slightly different direction. And I foreshadowed some of my thinking in my question to Professor/Ambassador Knox after the first session. As you've heard, there are some challenges to ecocide in the Rome Statute. And I thought maybe we should, Paul Williams started us off. There is no definition of ecocide. And so the way I like to think about the Stop Ecocide campaign, and this is their publication, you can see it on the web, I think it is a word that describes a phenomenon. I don't think it's a word that describes a crime. And why do I say that? Because we can use the term ecocide the way we use the term ethnic cleansing. We say this is a crime against the environment. This is significant harm to the environment. But when you look at, is it an actual crime? You saw lots of variety already, even in the presentations, because, for example, the Rome Statute provision on war crimes has an environmental crime in it. Is that ecocide? Is it a war crime? It's a war crime right now. So I want to just shift our conversation a little bit and get a little bit unattached to this concept of ecocide as a crime, because I do think there's not a very good fit between international criminal law, generally speaking, and this idea of harm to the environment as criminal. That said, the Ecocide campaign has done us a favor by catapulting this into public consciousness, and that was surely one of the really important aspects of their project. And it worked because everybody started talking about ecocide. Where I think there's a particular misfit between their objectives, which is largely to cover peacetime, not wartime, since we have a war crime of damage to the environment, is that the decision to take this as an amendment to the Rome Statute runs up against several problems. One of them is, of course, the problem that was already evoked, which in the ICC statute, who is potentially guilty? It's only individuals. But you saw already in the excellent examples that largely in the Fukushima case, it would be Japan. It's a state. And in many other situations, it would be a corporation, neither of which we can get at through ICC liability. Is ecocide customary international law? This was kind of the question that I asked in my first, because in order to add a new crime to the Rome Statute, in my view, it must be a crime under customary international law. I was pretty excited by Professor Knox's presentation that there were maybe 165 countries that had adopted in some way, constitutionally or otherwise, the notion of damage to the environment as a human right, at least, because I think that gives us a foundation for maybe arguing that damage to the environment could be a crime against humanity, not a separate new crime of ecocide, but a crime against humanity, because crimes against humanity is an existing category of international law, and we have seen that new crimes get added. So that's where my presentation is largely going to go, is on damage during peacetime to the environment as a potential crime against humanity. But I can talk about that more, and in the Q&A, I can expound upon why I think you must have a crime under customary international law for it to be successfully inserted into the ICC statute as a Rome Statute crime. I don't think you can just add stuff willy-nilly to the Rome Statute. The other problem, which is just a sheer practical problem, is states almost never ratify or ratify very slowly ICC amendments. So I looked this up quickly. The new Belgian, I think this was actually the Swiss amendment on starvation as a war crime, only has 14 ratifications. The removal, and that was from 2021, so it's relatively recent. But the aggression amendments, which were adopted by the ICC Assembly of States Parties in 2010, only 45 ratifications. The removal of Article 124, which should have been a no-brainer, that was accomplished. It was agreed at Kampala and accomplished by an amendment adopted in 2015. Article 24 is this little sort of transition additional provision in the Rome Statute that says a state can opt out of the war crimes jurisdiction for 7 years. Only 2 states ever used it, France and Colombia, and both actually then withdrew their objection and accepted the war crimes jurisdiction of the ICC. States agreed to take that out as inappropriate, and only 20 states have actually adopted the amendment removing Article 124 from the statute. What does that mean? Since it takes 7/8 of the 123 states of the ICC to actually make an amendment work for all states, that means that even the speed with which the ecocide campaign wants this done, and they think this is the fastest ways we're going to amend the Rome Statute, it could take over a decade, 2 decades for it to be useful even inside the ICC. Why does that matter? In the example, very thoughtfully, thank you, provided by my colleague here of Russia-Ukraine, Russia's a non-state party to the Rome Statute. So who would you want to be arguing is guilty for the air pollution? Presumably it would be the Russians, and you're not going to have jurisdiction over them. And Ukraine would have to adopt this new amendment because right now it wouldn't be applicable. So I think the ecocide campaign's decision to use the Rome Statute as the hook was great as a public relations consciousness raising. This is urgent. We need to get this done. Is it practical in terms of implementation? Significant obstacles. Doesn't mean it shouldn't be done or tried, but I want to suggest there might be actually other ways to do this. And one of the other ways, as I mentioned, is what about attacks on the environment as crimes against humanity? And here I want to evoke a slightly different narrative than Professor Stereo did. The International Law Commission in its work, and there's a great article by Christian Thomaschut on this, the International Law Commission had actually approved in 1986 any serious breach of an international obligation of essential importance for the safeguarding and preservation of the human environment as a crime against humanity. So we have a long history of the International Law Commission's engagement with the issue of crimes against humanity and the environment. It almost got into the 1991, was taken out, almost got into the 1996 draft Code of Crimes. Had the International Law Commission done that, I think it would have been in the Rome Statute, in spite of the fact that there were certain countries that objected to it. Now we have a new opportunity because there is sitting at the United Nations General Assembly that will be discussed in 3 weeks, the draft Convention on Crimes Against Humanity that was adopted by the International Law Commission and sent to the GA. And we have a 1-year timetable over the next year during which states have to decide whether to send it to a diplomatic conference, and the Austrians have already agreed to host the diplomatic conference, which is a really good thing because diplomatic conferences are expensive. About 109 states thus far have spoken in favor. There are a handful of states that are against. One can guess which ones they are: China, Russia, Iran, Syria, the states that one would expect to oppose. The United States, thankfully, is right now a staunch advocate of the new draft treaty on crimes against humanity. The Biden administration is extremely supportive, and there's a core group of states pushing to take this forward. I think the interesting question, well, first of all, to add this to crimes against humanity, right now the definition is based on the Rome Statute. There were good reasons for our project and the ILC to basically copy-paste the ICC statute when we did our work. That said, 25 years after the statute's adoption, the world has moved on, and we think there are equally good reasons to consider judicious, thoughtful expansion of the coverage of crimes against humanity to cover new offenses. The Gender Caucus is very strong. They want forced marriage in there. They want gender apartheid in there. They want indigenous groups covered by the crime of persecution, and the disabled have argued for the same thing. I think it may be time for sort of the environmental lobby, the ecocide group to say, hey, we've been messing around with this for 50 years with the International Law Commission saying, let's put crimes against humanity in as a crime, crimes against the environment in as a crime against humanity. And I think the definitional job will be tricky. I'm sure that Giovanni knows that. It's not going to be an easy draft. The ILC drafts were too short. Matthew Gillette has longer definitions, but I think it's very doable. And I think one nagging concern maybe the ecocide folks have is when you're talking about crimes against humanity, you are talking about humanity. You're not talking about crimes against the environment qua environment. So I think that is a concern of theirs, but I also think that plays into the very separation that caused humanity to destroy its own environment, which is, are we really separate from the environment, or are we part of the natural environment? So I think that kind of bifurcated thinking is actually the old kind of thinking that got us into the ecological crisis that we have now. And so I do think we can potentially fulfill the peacetime concern of the ecocide campaign by looking at a new draft treaty that's already there, that's being debated, and you have small island nations like Vanuatu or others who may be very excited to support a new treaty if it covers something that they really care about. It also provides for state responsibility. So we do get the state as perpetrator, as a potential defendant, or at least as a potential litigant in the ICJ, which is really where that would happen. They wouldn't be a defendant, but there could be ICJ cases brought because there's a compromissory clause included in the draft treaty. And the draft treaty includes corporate criminal liability. So liability of legal persons is already there. You wouldn't have to add that. So I think that is a potential extraordinarily exciting place to see this new crime come to fruition, or maybe repackage this old idea into a new treaty. You don't have to show its customary international law in the new treaty, just unlike the Rome Statute. It'll be hard to draft. Will it help get at the perpetrators we want to get at? Absolutely. Is it politically wise? I can't answer that, because obviously there will be resistance from some states. There'll be excitement from other states, and that, having been in Rome, I was only 14, like John when he was in the State Department. Having been at the Rome conference and watched the negotiations and watched those difficult compromises, I know that it won't be easy, but 25 years after the Rome Statute was negotiated, given the climate crisis and the ecological crisis we have today, really maybe this is a golden opportunity to include environmental crimes and environmental harm as a crime against humanity in the new draft treaty, particularly since the train has already left the station, and we could be at a new treaty including it in 18 to 24 months, which is pretty fast. So I'll just stop there, and thank you again for the invitation and for the excellent presentations that I could build on.
Thank you, Layla. Let's go ahead and move into the Q&A. I want to start by thanking my three panelists, Malena's three panelists, and more importantly, Ashma, who kept them all on time. I have never done that ever before on a panel, so kudos to you for keeping them on the line. Chile, you get the second comment. Amanda Price, the first one. Because Amanda wrote her law review article on ecocide, and so she's smarter than most of us up here. So Amanda, ask some questions or share some thoughts, and then Chile, you are next up.
Hi, my name's Amanda. I'm a 3L here at Case Western and the editor-in-chief of the Journal of International Law this year. I just want to take a moment to thank all of the panelists, both on stage and off stage, for taking the time and effort to be here today. It is so exciting to be here listening to you all. So as Professor Williams mentioned, I wrote my note on ecocide, and I looked at whether ecocide could be prosecuted by the ICC under the Rome Statute through the Crimes Against Humanity provision. So it had a bit of that human element that you mentioned. I was wondering, this is a question for the whole panel, it's a bit multifaceted, so feel free to answer some or all of it. Do you think that the international community is prepared to accept amendment of the Rome Statute to include ecocide? And if so, how do we handle the problem of addressing crimes of ecocide committed before adoption of amendment or done by countries who refuse to adopt amendment?
Great. So a simple question for our panelists. Who wants to jump in first?
Well, so the Rome Statute actually addresses this, right? The amendment only goes into effect prospectively. There's no retroactivity in the Rome Statute, and it only goes into effect for states that accept the amendment. So that means whichever states accept the amendment, it will be, I want to say, I could pull it up if you really want to know. I don't know if it's 1 year or 6 months after the day of ratification. And then from thenceforward, it would be implemented as for that state, but not for all the other Rome Statute states. So it could potentially be a slow process.
Giovanni, Milena, comments on that as well?
No, so I mean, I think Professor Sadat already talked about this in her presentation, that basically these amendments take a very, very long time. So even if some states in the international community are ready to accept, an amendment to the Rome Statute to include ecocide as a separate crime, I think that it would take a very, very long time for, the significant majority of states, in particular the 7/8 of all states parties that would have to accept the amendment. So, I share Professor Sadat's skepticism, perhaps pessimism, about the possibility of including a separate crime in the Rome Statute.
Yep. Just a short note regarding if the international community is ready or not. As far as I know, the European Union has discussed and expressed the positive the possibility to introduce ecocide into the Rome Statute. All the members of the European Union are members of the Rome Statute, but there are only 28 states. And then one thing is discuss and say, yes, we are available. One thing is go and amending and proposing amendment to the other state members. So let's see. I agree with both.
I think Giovanni just described international politics to you. Sure, great idea. What, you want us to do something about it? Well, thank you, Amanda. Chile, and then Beck.
Thank you very much. It was interesting to know that it allowed 14-year-olds to attend the Rome conference. I didn't go because I was less than 14, so they wouldn't allow me. Anyway, the point is, I was going to be on the panel, but I thought I had a few thoughts on the broader question whether whether the crime of ecocide is a fit international crime. My brief comment there. If we moved ourselves away from the weeds of this question, from a certain level of abstraction, appreciable one, it is a viable crime because we already see that kind of crime already in the Rome Statute. Article 82b, 4 of the Rome Statute has that. Article 35.3 of Additional Protocol 1 to the Geneva Conventions of 1949 has that. Article 55 also of that same protocol recognizes, again, the same kind of conduct. And the NMOD Convention of 1977, that is the Convention on Military and Other Hostile Uses of Environmental Modification Techniques, already, again, recognizes that kind of conduct, what we are talking about here. The difference is that those are recognized in the context of war, but then in appreciating why it is viable, I would say, let us consider what the ICJ said or did in the Corfu Channel case, where the court said, well, because of use of contact mines by Albania, or with the knowledge of Albania, that resulted in harm to shipping, military vessel of the UK, the ICJ said, well, we're not going to limit our analysis of the use of contact mines to what was provided for in the 8th Geneva Hague Convention of 1907 on use of contact mines, because that convention deals with war. And the ICJ then made this memorable pronouncement that there are certain concepts that are elementary principles of humanity, more exacting in peace than in war. If we begin from that analysis and we bounce back to the 1880 observations of the International Institute of International Law, Institut de Droit International, in the Oxford Manual, where they began by saying war is, however much we regret it and moan about war, that war plays a great role, has played a great role in the history of nations, because it is something on which animates states because of their vital interests and their existence. Because of that, let's not be hopeful too much that we'll soon get rid of war. And the reason I mentioned that is this: if wars would have this vitality to the interests of states and their survival, and yet we accept that Article 82b4 of the ICC statute, Article 35.3 of the Additional Protocol 1 would say, well, yes, we can fight war for those vital interests, but still there are just some things you cannot do. And here's the line: and those things you cannot do fall into the category of conduct we're talking about here. Whether we park it in the Rome Statute as an amendment to the Rome Statute, or whether we put it in a convention on crimes against humanity, or whether we give it a separate format in its own right, as we have a convention against genocide, I do think ultimately, if we're optimistic, we can see the viability of that as an international crime. Thank you.
Okay, so you can see a pathway to making it actually happen. Any panelists want to comment on Chile's optimism and pathway?
I might just point out that this is what I mean about terminology, though, because as codified in the Rome Statute, it's in Article 8 on war crimes. So it's a phenomenon of ecocide codified as environmental destruction in war. And the reason I gave the analogy to ethnic cleansing is listed in the World Summit Outcome Document in paragraph 138 as one of the 4 crimes against which states have, or 4 phenomena that states have a responsibility to protect against. But ethnic cleansing itself is not a crime. It can be the crime against humanity, or it can be genocide. And so there are 2 crimes that are often used to actually prosecute individuals accused of ethnic cleansing. And that's why I think there's a slight terminological issue. Ecocide as a rhetorical term, as an umbrella term, is an incredibly powerful instrument. And I think that is the genius of the ecocide campaign. As sort of a criminal lawyer who's had to work at the ICC for 10 years and tried to make sure, you've got to make sure you have the elements of the crime. And I think that's where the devil's going to be in the details, whether it goes in the Rome Statute. And remember, they spent 10 years on the crime of aggression, only to revert to the General Assembly Resolution 3314, which was from 1974. And it took the ICC, 7 years for the Special Working Group and a long time to get aggression done. So I think that detail part of it is the hard part of ecocide, and that's where we didn't really critique the definition. We took it at face value, but there's significant problems with the ecocide campaign definition. I don't think it would actually pass muster or be helpful at the ICC. So that would be a whole nother sort of issue that would be challenging.
Great. Any other thoughts on that before we turn the microphone to Beck? Beck Hamilton from one of the world's most renowned law schools.
Thanks, everybody. So I should disclose I am right in the thick of drafting an article called Criminalizing Ecocide, which I workshopped for the first time last week in front of John. And I 100% agree with you, Layla, about its powerful rhetorical punch. That's fine, and then there's a whole other conversation to be had about its criminalization. But my concern that I'm addressing in this article is how quickly, in the effort to make it a crime, how quickly the conversation has jumped to all of the practical and logistical problems that we've readily surfaced, right? You can't get jurisdiction over corporations, an amendment to the Rome Statute would be very difficult, et cetera, et cetera. But what I haven't seen, and I'm trying to work through, is what is the justification for making ecocide a crime at all in the first place? And to sort of sharpen that question, Giovanni, I was going to ask you, in relation to the example you gave of Russia-Ukraine, even assuming that it could fit under the definition standards, what is the argument for what prosecuting that as ecocide adds when, as it stands, we can prosecute it as a war crime of destruction of the environment, and to hear the sort of normative case for why that is important?
Over to you, Leila. Giovanni, sorry.
I start simply. I don't believe in the war crime and Article 8, Paragraph 2, Number 4. And then there is no prosecution, as far as I know, nowadays in the history of the ICC, of prosecution of this war crime. Because the principle of military necessity, I think it's absorb all the problem. I don't think it would be prosecutable, the air pollution consequences, and as a war crime. It would be too complicated. It would be prosecutable under the war crime, for example, one case that I didn't mention, the destruction of the dam, Kakova Dam. This would probably, yes, there is no proportionality. They killed, there is a report that they killed 100,000 of migratory birds, for example. It would be prosecutable in theory, in my opinion, under a war crime against the environment. But the air pollution consequences, in my opinion, are not prosecutable currently under this reform.
Take the dam example. I wasn't reading the air aspect, but I'm saying, what do you get by prosecuting as genocide as opposed to
As genocide?
a crime, as a war crime?
Can you repeat that?
Sorry. Change the facts. So assume that you can prosecute it as a war crime for environmental destruction under the Rome Statute. What do you get additionally? What's the additional value of prosecuting it instead as ecocide? What can you get out of a future ecocide prosecution that you can't get out of a war crimes prosecution?
All right. Yeah, in my opinion, under the definition of the Stop Ecocide Foundation, ecocide is the worst mass environment destruction that can be committed, while the war crime against the environment is a common war crime against the environment. So it's, I know it's
a higher expressive.
Yeah, exactly. It's like genocide.
If I can just add one sentence on this, I think also going back to what Giovanni just said about basically how we even though we do have this war crime, nobody has ever been charged with it. And I think there's this notion, as prosecutors have limited time and resources and are trying to prioritize certain cases, certain prosecutions, if they can prosecute other things as war crimes, they might never get to it. And so I think, again, I don't disagree with anything that Leila has said about issues with perhaps the definition or I realize there's significant challenges, but I do think the value of having a separate crime of ecocide is that you might actually see prosecutions if we have it as a separate crime, as opposed to it's subsumed within war crimes and we've never seen anybody charged with the offense. So whether it happens or not, I don't know, but yeah.
But I might, if I could just jump in, one of the reasons it would be, Prosecutor Bensuda announced she was going to try to do this, and it wasn't done. She had no resources, and then Trump sanctioned her, so it was kind of a mess at the end. Kareem Khan has said he is going to do a policy next year, and I had a conversation with him this summer, and I really encouraged him to do this quickly. Why? Because the message I guess you would be trying to send, going to the expressive value of the criminal law, is folks, when you do your targeting calculations and you take your command decisions, you must seriously consider the environment amongst the factors, not just because it's written here, but because you could go to jail if you get that wrong. And what we don't have is we don't have a case saying you could actually end up in prison for getting that wrong. And of course, they set the bar so high that it's going to be easy to defend against. And so that's why I think it is important for the prosecutor to use the law he's got now. We've also talked about how could we use other inhumane acts, draining the marsh by Saddam Hussein. That created conditions of life that were inhospitable to the survival of humans. What happened in Darfur, charging those as environmental crimes, I think does potentially, I'm not sold on that. We're all thinking aloud, but I think having it sit there and doing nothing with it is harmful to the cause of trying to bring our consciousness of the environment up. So that's what I would say.
Thanks, Beck, for stirring the beehive. Over here.
What are the mechanisms of influence that large multinational corporations and offending nations have at their disposal to inhibit ecocide legislation from being passed?
And tell us who you are and where you're from.
My name is Chad Wiseman. I'm a third-year law student at Case.
Great. Easy softball question. Let's see how your panel handles that.
Not like I have specific examples, but we all know that large multinational corporations and even large domestic corporations have a tremendous amount of power when it comes to lobbying their national governments to pass certain laws or not to pass certain laws. So I think this is, we're talking about the same thing here.
Well, and especially in the United States, because corporations have legal personality in spades, right, and can contribute to campaigns. It is one of the political calculations thinking about putting environmental harm in the Crimes Against Humanity Treaty is we will stir that nest because the combination of environmental harm and liability of legal persons in a new international criminal law instrument could all of a sudden get states that are right now very supportive because they don't see themselves on the receiving end to go, oh, wait a minute, right? So they have a lot of power.
Maybe we could have them, choose between using their lobbying dollars for their private jets and their super yachts or battling against the crime of ecocide. We might have to call Victoria and call a friend to have her answer that question. Mr. Scharf, Dean Scharf.
So I'm going to build on Layla's comment where she mentioned that in Iraq, Saddam Hussein drained the swamps in order to attack the Marsh Arabs, who he saw as their opponents. And Milena said, well, there just aren't any precedents of courts deciding this issue. But the case that the Iraqi High Tribunal decided against Saddam Hussein, called the Dajjal case, and then the other cases that followed, they were ghost-written, or at least written with the support of Howard Morrison, a wonderful jurist from the UK who ended up being a judge on the ICC. They decided as a legal precedent that it was a crime against humanity and a war crime to dry up the Marsh Arabs. So you have that precedent. I know not everybody, loves the decisions that came out of the Iraqi High Tribunal for a variety of reasons, but it's out there and it's written by a very respected jurist. It's good writing too. So it's helpful to look at. Just wanted to point that out. Thanks.
Thanks, Michael. Any comments on that from the panel?
I actually have if I can jump in, but it's actually a question for
question.
Layla, because you actually just mentioned this and we didn't have time to discuss it. So on crimes against humanity, what about including, environmental crimes within the catch-all other inhumane acts, provision of the definition of crimes against humanity that we have within the Rome Statute already?
So, especially for the students in the room, crimes against humanity are a compound crime. There's a contextual element that said it has to be a widespread system or systematic attack against a civilian population pursuant to a state or organizational policy. And that kicks it up to a mass atrocity, right? And then you have a whole list of acts: murder, extermination, deportation, torture, and then at the very end, persecution, which is important for things like attacks on the Marsh Arabs or other situations. And then at the end, they have other inhumane acts. And so other inhumane acts is absolutely a place where right now I think the ICC prosecutor could put environmental harm. It also could be in murder if you have enough, but it is a murder, so you have to show intentionality. It's not going to be easy. In the genocide provision of Article 6, you have conditions of life calculated to bring about essentially, in whole or in part, the destruction of the group. And that, I think, goes to the Dujail case that Dean Scharf was referencing. So we do have language in, it would be a new use of the existing language, I think completely doable and viable, just as forced marriage was initially encompassed in the tribunals as an other inhumane act, and now the argument is that it's been accepted at the Rome Statute, by the Special Court for Ceylon, and at the Cambodia Tribunal. So let's just put it into the new definition of crimes against humanity. And gender activist groups, the Global Justice Center is pushing for that in the new draft. So I think we can use the existing law. That doesn't necessarily fulfill our expressive value concerns, which is, I think, what the Ecocide campaign was, and you know, I'm still learning about this, and there's an excitement that's been generated about their campaign that I think is hugely, hugely positive. It's just the implementation of it is challenging once you start getting into drafting details. The only other thing I'd say, Paul, which is important, is there's going to be a question, do we just have a general definition the way they did, or do we have to have specific acts that constitute the acts that are justiciable? And that, I think, is going to be a fight. Matthew Gillette has a great piece up on Just Security listing what acts he thinks would be justiciable or you could condemn somebody for. Others say, let's just use a generic definition like we did for the war crimes in Article 8. So I think that's a really interesting conversation that's going to be had as well.
Great. Thank you, Layla. Please join me in thanking our amazing panelists for their conversation and for your questions.